The courtroom tension starts instantly. Mr. Garcia steps forward, confused and defensive, already disputing who his attorney even is. That's never a good sign. Within seconds, we see the cracks: mistrust, miscommunication, and frustration. This isn't a calm plea hearing, it's a storm brewing under pressure. And when he claims the indictment is wrong, saying he's never been convicted of manslaughter, the whole courtroom shifts. The question is Garcia misunderstood, or is he rewriting his past to dodge accountability? Either way, this opening sets up a clash between perception, paperwork, and truth.
Mr. Garcia, in each of the cause numbers, did you have a chance to review the true bill of indictments with your attorney?
I looked at them, yes.
All right.
But
So-
Your Honor, I was under the impression I had a different attorney. When I went to the PR jet, they told me Michael De Leon.
No, this
Because
is
when
your
I came to
attorney.
Work with him the first time, I told him I didn't want him to be my attorney.
Well, this is your attorney,
I was
counsel.
satisfied with his service.
Well, he's your attorney. Do you understand?
I'm satisfied with I want to withdraw my plea. Because the indictments aren't correct anyways. I've never been convicted of a manslaughter.
Mhm.
And it says I've been convicted of a manslaughter on there. I wasn't in possession of a gun. It was in the glove box of a car that's not even in my name. That I told him I would sign a statement saying that the gun belonged to the owner of the car.
No, so here's the thing, and I'm going to explain some things to you. Owning a weapon, if you have a prior felony, it's not so much whether you own a weapon, it's whether you're in possession of it. And it doesn't matter when you went to prison. If you went to prison,
When Garcia argues the gun wasn't his, and it was in the glove box of a car, not in his name, the legal problem is obvious. Possession doesn't require ownership. If you know it's there and have control of the vehicle, that's enough. The judge's calm tone hides a warning. It's not about who owned the gun, it's about who could reach it. She's educating him and, indirectly, the audience. The law can be cold. It cares less about stories and more about access and intent.
you're not allowed during specific timeframes, during anniversary dates, you're not allowed to.
I was
Possess a
16,
weapon.
Your Honor. I was a minor, from 1989.
All righty. Well, I mean, what are you talking about? What was from 1989?
The gun and the manslaughter that they're talking about. I was a minor. I was a
Oh,
juvenile.
so
I was
you are the
25.
person with the voluntary manslaughter. It was just when you were 15.
No, I never had one.
You just
That's
told me you did.
correct. That's what I said, what they're saying I had. That's wrong. I've never been convicted. So that indictment's not even correct.
You just told me that's who you were.
No, that
You
was
said when
not-
you were
I-
15.
I said when they said I was 15, I was 15 years old, but they're accusing me of that.
Mhm.
But I never went to court for that. I've never been convicted of that.
And
Well-
the state's waiving that paragraph.
I did waive that, Your Honor. So
That's
I'm
from
not sure.
Cleveland, Ohio. That's not even from here. That's from
So
over 20 years ago, man.
I understand that. I waived it. So we're not accusing him of having been convicted of a voluntary manslaughter. We
Well, they didn't
did,
give me a chance for probation, but everybody else had the same cases. I'm listening to them today. The second-degree felony.
Then comes the twist. Garcia says he was a minor back in 1989. The judge pounces. So, you are the person with the voluntary manslaughter. Suddenly, his words trap him. You can feel the shift. He tries to walk it back, saying, I never have. This back and forth is critical because in a courtroom, contradictions can destroy credibility faster than any prior conviction. Whether or not that old record stands, the damage is done. The judge now sees a man who's not fully transparent, and that's dangerous in plea negotiations.
And you're giving them probation and deferred beautification. I haven't been in trouble in 20 years. I'm 52 years old. I go do 10 years. I'm probably won't even make it out alive because of all the game in the prison. I've never been in trouble in Texas. Never. Never, man. But you won't give me a chance at probation, but you give everybody else that has a long record a chance at probation. And they have the same cases as mine.
All right, so I'll tell you this, Mr. Garcia. What I do know is you can't compare your case to somebody else's case because you don't,
understand that.
but here's the thing. You don't know what evidence they may or may not have had with that person because every case is different. Sometimes people will say, I can't believe this person who is charged with a murder got 5 years and here you are offering me 40 years. It's because every case is different. And I understand that sometimes people have changed their lives, right? And they want people to recognize that they've changed their lives. But
This next moment is powerful. Garcia pleads for fairness, saying others with the same cases got probation. It's a plea many defendants make comparing outcomes. But the judge delivers a sharp reality check. Every case is different. That's not just courtroom talk, it's legal truth. No two cases carry the same facts, evidence, or history. Garcia is trying to argue equality, the judge is enforcing individuality. This is where emotion meets law, and emotion always loses. Still, there's something painfully human in his words, a man begging for one more chance before the system shuts him out for good.
I'm just dealing with cases before me. Either I'm going to follow a plea agreement that you all have reached, or either I'm not going to follow the agreement. That's where we are. So, Mr. Garcia, the indictments are to tell you what you're being charged with. So in 2024 CR 0090-02, you're being in charge with unlawful possession of a firearm by a felon. And in 2025 CR 012431, there are 2 counts. The first count, you're being charged with manufacturing and delivery, a controlled substance, penalty group 1, 4 to 200 grams. Count 2 is possession of a controlled substance, penalty group 1, 4 to 200 grams. What I can tell you is, when you have just, this is what I want you to do. This is what I want you to do. I want you to listen, okay? This is just what you're charged with. Now, the state and the defense.
Now the judge starts reading the indictments, and you can hear her patience thinning. These aren't small charges: unlawful possession of a firearm and manufacturing a controlled substance. It's not one mistake, it's multiple felonies. The way she lists 2024 and 2025 cases shows Garcia's criminal timeline stretching across years. But the real tension, he's still hoping this will end with probation. That gap between his hope and the law's reality is what makes this courtroom moment sting.
May come to an agreement to say, this is what you're charged with, but we're going to go on a lesser included offense. Or they may say, this is what you're charged with in counts 1 or count 2, but we're only going to proceed on count 2. What I'm telling you is, I haven't even got to the point of what your plea bargain agreement is. I'm just showing you the indictments. This is what you're being charged with. Do you understand?
Yes.
And counsel, did you go over the indictments with Mr. Garcia and explain it to him? Do you waive the reading of the indictment? State, in the cause number 2025 CR 012431, which is the drug case, are you proceeding on the indictment as presented?
We are not, Your Honor. We are waiving count 1, which is the Mandel count, and we are only proceeding on the possession count.
All right, any objections to the waiver?
No.
And then in the cause number 2024 CR 0090-02, which is the weapons case, are you proceeding on that indictment as presented?
We are not, Your Honor. We are waiving both of the enhancement paragraphs and proceeding only on the allegations contained in the jurisdictional offense, unlawful possession of a firearm by a felon.
Any objections?
No.
Now, Mr. Garcia.
When the judge warns that she doesn't have to follow any plea agreement, that's a crucial line many viewers miss. Even if both sides agree on a deal, the judge has ultimate authority. She can reject the plea entirely if she believes it's too lenient or unjust. That single statement changes everything. Garcia's face says it all. He's realizing that his fate isn't in his lawyer's hands, or even the prosecutor's. It's in the judge's. That's when the real weight of the courtroom hits. One decision can override every expectation.
I'm going to show you the court admonishments. These documents tell you what your rights are, and it also contains in it what your plea bargain is that you have negotiated with the state. Now, because you've negotiated a plea bargain agreement with the state, that doesn't necessarily mean that I will follow the agreement. I'll have to read the stipulations and everything else. So in 2024 CR 00902, I'm sorry, 90-02, You're charged with unlawful possession of a firearm by a felon. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. In 2025 CR 012431, you're charged with possession of a controlled substance, penalty group 1B, 4 to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years with a possible fine up to $10,000. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
This section is pure law in action. The judge carefully explains Garcia's rights: jury trial, cross-examination, silence. These moments might sound procedural, but they're fundamental. Because later, when defendants claim, "I didn't understand my plea," this exact dialogue protects the record. It's the judge's legal shield. Still, look closer. Garcia's responses are clipped, almost mechanical. Yes, sure, it's not the tone of someone absorbing the gravity of 10 years. It's the tone of a man already defeated. And that detachment says a lot more than words.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these pleas, you're giving up those rights? And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yeah.
Counsel, has your client been able to provide you with any defenses?
Yeah.
Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yeah.
All right, if you're not a US citizen, by entering into these pleas, you will be deported, denied naturalization, or re-entry. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause numbers, did you review the plea bargain page with your attorney? Did you understand it? In each cause number, your punishment is to be assessed at 10 years in the prison. There's a $1,500 fine. The cases will run concurrently. The state is taking in consideration 2025 C 011469.
At this point, Garcia pleads guilty. But the contrast is striking. After minutes of protest and denial, he suddenly accepts guilt. That pivot might confuse viewers, but legally, it's strategic. Pleading guilty often trades trial risk for sentencing leniency. Yet, the emotional disconnect remains. How does a man claiming innocence 1 minute accept guilt the next? Maybe it's exhaustion. Maybe it's fear. Either way, this shift highlights the courtroom's power dynamic the system pushes. And eventually, most defendants yield.
Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, ma'am.
Did you review the waiver of appeal paragraphs with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
None.
And cause number 2024 CR 0090-02. How do you plead? Guilty, not guilty, or no contest? And cause number 2025 CR 012431. How do you plead? State, any evidence?
In both causes, Your Honor, the state offers into evidence States Exhibit 1 and its
Okay.
Right, in each cause number, did you review the waivers and stipulations?
Yes.
Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, in the right to remain silent. Did you understand in entering these pleas, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will
Here, the judge officially finds Garcia guilty in both causes, But what stands out is her calm tone, no drama, no bias, just procedure. Yet behind that calmness lies finality. Every word she reads cements Garcia's fate, 2 concurrent 10-year sentences. No appeal rights, no probation, just time. What's fascinating is how matter-of-factly it's delivered, like a line item on a form. That's what true courtroom reality looks like. Justice doesn't always shout. Sometimes it just signs papers.
Find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you waiving PSI?
Yeah.
Anything you wish to say on behalf of your client?
Other than that, the previous convictions were 20 years ago.
Here. Now, Mr. Garcia. On the drug case, I read the police report.
Then the truth lands hard. The drugs weren't found in a car or a house, they were in Garcia's pocket. That kills any plausible defense. The judge's tone turns instructional again. You're going to have to start doing the right thing. It's not anger, it's disappointment, the kind that hits deeper. In these moments, judges stop being distant figures and start sounding like parents who've seen too many lost chances. And that's what makes this case powerful. It's not just about the law, it's about wasted potential.
And in the police report, you had the drugs in your pocket.
Won't deny that.
Yeah, so I mean, in the drugs you had in your pocket, the weight of the drugs was 28.564 grams.
Yeah, good. No.
So, I mean, here's the thing. I understand nobody wants to go to prison, right? But you're gonna have to start doing the right thing. So in cause number 2025 CR 012431, the court will find you guilty. The court will sentence you to 10 years, give you credit for any time served. There's a $1,500 fine, time and money to run concurrently. Taking consideration 2025 CC 011469. And this will run concurrent with 2024 CR 0090-02. And then in the other cause number, you admitted.
When the judge reviews the weapons case, she highlights custody and control. This is a key legal principle viewers should understand. Possession doesn't mean holding something, it means having the power to control it. So even if that gun was in the glove box, Garcia admitting knowledge makes him legally in possession. It's a cold reminder that the law isn't about emotion, it's about facts and statements. And in that moment, his own words sealed his conviction.
That there was a weapon in the vehicle.
Glove box.
Yeah, I mean, you told the police, yes, there's a weapon in the vehicle. So that's care, custody, and control, and you're considered to be in possession. And you're not allowed to do that because of your criminal history. So in cause number 2024 CR 00902, the court is finding you guilty. Court will sentence you to 10 years in the prison, give you credit for any time served. There's a $1,500 fine. This will run concurrent with 2025 CR 012431 and 2025 CC 011469 will be taken in consideration. Is there anything else, counsel, with regards to sentencing?
As the sentencing wraps up, the judge delivers the kind of line that sticks. If you don't start making better decisions, you'll find yourself living at the prison. That's not metaphor, it's prophecy. It's what happens when a lifetime of small choices finally adds up. Garcia's quiet yes is haunting. It's the sound of someone who knows the road ahead, and that it's one he built himself.
And each cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Just only sign.
Oh, I'm,
That's
the
good.
county court, you'll have to
Oh,
take
okay.
it there. They
All
don't
right.
want us signing.
Which one, 12? Okay.
Yes. Well, yeah. All right. Did you review the trial court certification tells you whether or not you have the right to appeal? Now, because I followed your plea bargaining agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand? All right, we can go off the record, Mr. Garcia. If you don't start making better decisions, you're going to find yourself living at the prison. You understand? All right, good luck to you, sir. Thank you, attorney.
Thanks, guys.
All right, thank you, Fernando. Who's next?
This case is a sobering example of how the justice system works and how fast it moves once the truth is locked in. Despite Garcia's emotional pleas and decades without trouble, the facts and the law aligned against him. The court followed procedure, the plea stood, and justice was delivered calmly, methodically, and finally. But here's the question: was this justice or just inevitability? Tell us what you think. And if this courtroom breakdown kept you hooked, hit that like, share your thoughts below, and subscribe for more powerful real-life cases where every word matters.